I'll let her.
You were given an
obviously let her
opportunity, yeah, so you were given an opportunity to go to ISF and you said, "No, I don't want to do that," right?
I was kind of scared and didn't know, like, with the courts.
Well, I mean, ISF would be better than prison.
Yes,
And I know there's a lot of females in there that don't have a stack of write-ups like this.
yes, ma'am.
They don't call officers bitches. We're looking at 2 weeks ago. Bitch, you've been waiting all day to just write me up. You don't. So you're on felony probation and you're using drugs, knowing it could send you to prison, and you don't think that's a problem.
Today we're in Judge West's courtroom and it's already a full-blown circus with multiple defendants all staring down years behind bars. You can practically feel the desperation leaking off of them like a bad cologne the moment they realize today is not going to be their lucky day. Every single one of them came armed with excuses, long, dramatic ones, yet not a shred of actual accountability in sight. It's like watching a lineup of people who all swear they didn't do anything, while the evidence is sitting right behind them waving hello. Judge West isn't buying a word of it, and honestly, who would when all the stories sound like they're made from leftover scraps of courtroom TikToks? The tension is real, the stakes are high, and this bench has zero patience for nonsense. So the real question is, who's about to fold first under pressure? Let's go ahead and dive in.
Mr. Chambers, in cause number 2137015, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 14th of 2022 for the offense of aggravated assault, family violence, second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department February 12th, February 28th, April 8th, and May 8th of 2024. And how do you plead to that charge? I mean, is that true or not true? I'm sorry. And then count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you provided a urine sample January 22nd and April 22nd of 2024 that tested positive for tetrahydrocannabinol. And is that true or not true? THC, marijuana. Is that true? Count 4 alleges that you failed to provide verification of performing your community service hours. And is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the Battering Intervention and Prevention Program. Is that true or not true?
I have a certificate that I completed the program.
Okay. Count 6 alleges that you failed to submit to alcohol or drug screening March 22nd of 2024. And is that true or not true?
No.
So it'd be not true. 2, 6. Count 7 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy, the MRT program. Is that true or not true?
I don't know, because she told me to complete the bill class first, and I complete the bill class.
Okay, so I'll put not true for 7.
I never start the other class, because that's the class you do at the program.
I'm not sure.
No, I never start the one on the class.
Okay. Count 8 alleges you're behind in your court-assessed fees as of May 21st, 2024 in the amount of $225. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 3, 4, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
And do you fully understand them?
Yes.
And you understand if I follow the agreement you made with the district attorney, you'll be waiving or giving up any right to appeal.
Yes.
And the agreement that you've reached is for a cap of 5 years. So I can give you 5 years if I revoke your probation. I can give you less. It'll all depend on the information I receive at a sentencing hearing. Do you understand?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Chambers is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do an updated report. That'll give me more information about you, your case, and then we'll come back for sentencing. All right, you can go back with the bailiff.
This man's facing an aggravated assault charge, and even with a 5-year cap, that's still serious time, yet he thought it was a genius idea to break half of the conditions of his probation like they were optional. The judge is reading these violations off like she's going through a Costco receipt, just line after line. And somehow this guy still has the audacity to plead not true to some of them, which is wild considering most of the conditions are black and white facts. The no employment one especially, why would probation lie about whether or not you have a job? You either clock in somewhere or you don't. It's really not philosophical. I'm honestly looking forward to his sentencing hearing because I need to hear what kind of story he plans on telling for all of these not true claims. And truthfully, whether you break one condition or all of them, the whole point of probation is don't break any. It's not a punch card system. The fact that the state and defense agreed on only a 5-year cap is shocking because this guy basically spit in the court's face with the amount of disrespect he showed to the rules. He violated drug conditions, location conditions, reporting conditions, you name it. It's the kind of behavior that sends a very clear message. I don't care what the court says, I do what I want. And that's exactly how you end up walking straight into a sentence you could have avoided. If anything, he's the perfect example of how probation is a privilege, not a guaranteed second chance.
All right, are you Reagan Howard?
Yes, ma'am.
And Ms. Howard, you're in cause number 22-39924 on probation for deadly conduct, discharging a firearm, given a 6-year deferred probation, June 10th of 2024. Motion to revoke was filed. Entered pleas of true to counts, looks like 1 through 9, and then 11, 12, and 13. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Defense has, right?
Mr. Kimler, go ahead.
Your Honor, Ms. Howard has struggled on probation, and I say that really, it was a kind of a polite way of saying she really hasn't done a whole lot while she's been on probation, except test positive for THC and alcohol. In talking with her and trying to understand why she didn't make more of an effort on probation, I think that she, again, and I'm perhaps sound like a broken record in these cases, but I do think she's suffering from some underlying mental health issues that have to do with depression. The court would note in the report that she did have a stillbirth, and I think that that's affected her. Of course, that's not an excuse, but and then of course she refused the help with ISF and substance abuse. And again, I'm not an expert, but I think part of her problems with THC and alcohol stem from self-medication, and I do think she would benefit from ISF substance abuse, and she, I believe, wants to do that now. But really, she needs treatment for depression and get her serotonin levels back. I mean, again, I'm not an expert, but to get her serotonin levels balanced out, and perhaps she would perform better. I think she's had an opportunity since she's been in jail, I believe about around 120 days, to reflect and introspect and gain some insight into her position here. And she's told me during our discussions that she does want to keep a felony off of her record. She does have plans for the future that a felony would compromise. And she really wants to do the probation and is willing to do the ISF. Now I know I've looked at these incident reports from the jail, and it seems that this is kind of a recurrence with people that are detained pending resolutions of these NPPs for these reports to be generated. And I'm not questioning or harassing the reports. I'll just note that it appears to me from looking at the reports that they all derive from her interactions with one corrections officer.
Not all, but most.
Well, most of it, but then again, I'll leave it to Ms. Howard to kind of explain that to you, maybe what's going on there at the jail with these reports. She has a support system available. These women in the back are all here in support of her. So she has that going for her too. I think that she can do the probation, Your Honor. It's a question of whether she's sufficiently motivated. And again,
Well, why didn't you go to ISF? Why did you?
I'll let her.
You were given an
opportunity.
opportunity. So you were given an opportunity to go to ISF, and you said, "I don't want to do that." Right?
I was kind of scared and didn't know like what the courts was gonna tell me, and
Well, I mean, ISF would be better than prison.
Yes, ma'am, I know that, but I was just scared I wanted to just buy me some time and actually do my probation. Cause I know I admit to all my wrongdoings, I wasn't ready to go to prison or ISF.
But you know it's gonna be one or the other.
Yes, ma'am.
You're not gonna not do all this and me go, okay, well, let's go right back out on probation.
Yes.
You know it doesn't work like that.
Yes, ma'am.
So tell me what's going on with you and Miss Bobo.
I'm not gonna say she picks, but it's a lot of picking going on with that officer.
Do you think if you, from day one, were just following the rules,
Yes, ma'am.
that you probably wouldn't have that issue?
Yes, ma'am.
You know what I mean?
Yes, ma'am.
So, from what I can tell, from the time you got in there, you didn't follow the rules right.
Yes, ma'am.
She got frustrated, and then it's all right.
Well, I don't want her to interrupt you.
It's okay. She got frustrated probably pretty quick because her job is just to try to make you guys follow the rules. When you're not, then they're gonna pick because you're still not following the rules.
Yes, ma'am.
You know what I mean? So if you did that from the beginning, she wouldn't have been watching you more closely. She wouldn't have been worried maybe so much. But if you continue to break the rules, it's her job to enforce those rules. That's not picking, right?
Yes, ma'am.
That's enforcing the rules. It's just there to do her job. And I know there's a lot of females in there that don't have a stack of write-ups like this.
Yes, ma'am.
They don't call officers bitches. You know? We're looking at 2 weeks ago. Bitch, you've been waiting all day to just write me up. That's after all these pages of the other incident reports. She probably is waiting to write you up because she knows you're not going to follow the rules.
Yes, ma'am.
Okay? Mr. Smith?
Now this second defendant right here is the classic, I only want help once I'm caught case. The moment drugs or alcohol show up on a test, suddenly they want treatment, support, guidance, all the things they refused when the judge offered ISF at the very beginning. They swear they'll do fine on probation, then everything collapses, and suddenly their problems are too overwhelming to manage. It starts sounding less like a plea for help and more like a strategy to dodge jail time. And you can absolutely tell when someone's trying to play on the court's sympathy. It shows in every word and every excuse. Let me know in the comments if you honestly believe she has a real drug or mental health issue, because I'm not buying any of it. If I were the judge, I wouldn't have entertained ISF this time around. It would have been straight to jail for wasting the court's time. There should be a rule that if you refuse help the first time, you don't get to come back crying for it later. And what really seals the deal is that she's causing problems in custody, arguing with guards, cussing them out, acting like she's being targeted. That's not needing help, that's showing the exact behavior that makes probation officers keep both eyes on you at all times.
Judges, seems like deja vu all over again. She has an issue with apparently cocaine, THC, and alcohol. She was offered a chance to take care of that, and she basically said, no, I'm not going. I don't want to go. I don't need help.
Do you think you need help?
With my depression, I don't think I have a drug problem.
You don't? So you're on felony probation, and you're using drugs, knowing it could send you to prison,
Yes.
and you don't think that's a problem?
It's a problem.
Okay.
Yes.
She was using THC up until the day before she was arrested. I think she's saying that now just so that she doesn't wind up going to prison. I don't think it's going to be effective enough.
Thank you, Mr. Smith. So I don't disagree with Mr. Smith. Ms. Howard, you're on probation for something very serious, but you don't have a lot of criminal history. I mean, you're one of the ones that should be able to complete this.
Yes, ma'am. And
You
I
know.
can.
I don't doubt that. I mean, you've got people here. Not everybody has people sitting here in the courtroom when they come to court.
Yes, ma'am.
Some people really are on their own. But you're not using that help through probation, through your family. And if you don't, you are going to end up in prison.
Yes, ma'am.
So here's what I'm going to do, and I don't want you to misunderstand anything I'm about to say, because this is your chance. And there's going to be a very important caveat to all of this, and that's going to include not getting in trouble Talking about that in a minute. We're going to find that you entered your pleas of true to count 1 through 9 and 11 through 13 freely and voluntarily. Find those counts true.
Yes, ma'am.
Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to continue you on probation. I am going to order that you enter and successfully complete the ISF, the substance abuse track of the ISF program. When you get out of that, the aftercare will be the JCDI program, and you're going to be on zero tolerance.
Right here is the turning point. The judge is giving her one final lifeline, but it comes with zero tolerance. One mistake from this moment forward, and she's not just back in court, she's heading straight to prison.
To be a condition of your probation that you not get another write-up.
Yes, ma'am.
So you're going to be in our jail for a couple of weeks before they send you to ISF. You better figure out how to stay off Miss Bobo's list.
Yes, ma'am.
Whatever it takes. You do every single thing you're supposed to. Just be quiet. Just be quiet for 2 weeks. Follow every single rule to a T, because you may not ever get out of our jail. I will check, and if I get a report, you will be back in here before you ever get to ISF. If you get to ISF and there's somebody that you think's picking on you and you get incident reports there, same thing. So it's time to figure out that at least while you're in custody, you got to do what everybody else says. When you're out of custody and you're not on a felony probation, then you get to follow your rules. Until then, you're on all of these rules. And it's not always you eat when they tell you to eat. You go to bed when they tell you to go to bed. You wear your jumpsuit the way they tell you to wear your jumpsuit. You don't talk when they tell you not to talk. You don't sit on a bunk when you're supposed to stand. All those things. It's like being treated like a kid, but that's what happens when you are on a felony probation. Does that make sense?
Yes, ma'am.
Thank you all for being here. Thank you. Good luck to you.
I'm honestly stunned she got that sentencing. ISF now, then straight back to probation after completing it, despite her mountain of violations. Maybe that's why I'm not the judge, because nothing about her attitude suggested remorse or even basic awareness of what she'd done. She wasn't sorry in court, she wasn't sorry in custody, and she certainly didn't act sorry when she racked up those write-ups. Judge West must have been in an unusually generous mood to give her another chance like that. But make no mistake, she's officially on her last lifeline now. The judge spelled it out crystal clear, no more write-ups whatsoever, or she'll be back in this courtroom faster than she can finish a sentence. Comment below, do you think the judge made the right call sending her to ISF first, or should she have gone straight to real jail? Because the way she insisted she doesn't have a drug problem should have removed ISF from the table entirely. If you say you don't have a problem, then why are we sending you to treatment? At that point, it's not about recovery, it's about refusing to follow rules, and there's really only one place people like that end up.
Mr. Papania, in cause number 17-26995, I have a motion to revoke your community supervision. Shows that you were placed on probation October 2nd of 2017 for the offense of driving while intoxicated. And that was an 8-year sentence that was probated for 8 years. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you provided a urine sample July 28th of 2025 for tested positive for tetrahydrocannabinol. Is that true or not true? And then count 2 alleges that you failed to provide verification of attending program guidelines and rules of the Mental Health Initiative caseload. Is that true or not true? Count 3 alleges that you failed to adhere to the conditions of the interlock program as required, in that May 21st, there was a high blood alcohol of 0.037. May 23rd, there was a high alcohol reading of 0.111. June 14th, 2025, there was a high alcohol of 0.034. And then June 21st of 2025, there was a high alcohol reading of 0.033. And is that true or not true?
True.
Count 4 alleges that you are behind in your court-assessed fees as of July 29th of 2025 in the amount of $4,730. Is that true or not true?
That's true.
Did you enter your pleas of true to counts 1, 3, and 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to those counts freely and voluntarily. Find them true. Find sufficient evidence to revoke your probation. I'm not going to do that today. I'm going to reset your case for an updated pre-sentence report That will give me more information about you, your probation, what's been going on, and then we will come back at a later date for sentencing.
Your Honor, we're requesting a PSI bond. I mean, he has admitted to his violations. I will represent to the court that I know for a fact that he's moved from his area. He's actually, I didn't know this at the time, he's actually up in the Conroe area right where I have a lake house, and he's
Let me
working.
just stop you.
Okay.
DWI third, and the violations are high blood alcohol readings and testing positive for THC. So I want updated report to see what's going on. I'm not going to grant a bond at this time. If I continue probation, it would be likely with some type of treatment. I'm not sure. I just need to get some more information. So I'm not going to give a bond at this time.
Okay.
All right, you can go back with the bailiff. All right, are you Ashley Faye? And Ms. Faye was previously in court, entered a plea of guilty to the third-degree felony offense. Well, and it was a state jail that was enhanced to a third degree of credit debit card abuse. The agreement was for a cap of 5 years. And I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We have, Your Honor.
Yes, Your Honor.
Are there any additions or corrections?
Just a comment as to what Ms. Faye's comments were, Judge. It appears that she's not taking responsibility. I spoke with her about that. I think
I was just kind of confused the way it was worded. I didn't know what, I was never really truly told like the specific on the case, like.
Did you use somebody else's credit or debit card?
It was me and my friend did.
Okay.
And I didn't understand how she worded it.
Okay,
But yes, I did.
okay.
that's the only correction I had, Judge.
Any corrections, Mr.
Nothing I
Nichols?
saw, Your Honor.
Also, in addition to that report, I have received just not, looks like a few pages of jail incident reports that I've reviewed as well. Has everyone received those?
We have, Your Honor.
All right, you may proceed with the argument.
Yeah, Judge, I think looking at her criminal history, it doesn't scream that this is someone that deserves a chance on probation. That's what she's asking for, however. If you look at her comments on page 4, she's asking for Santa Maria. We've already talked about that a little bit this morning. She's indicated to the probation officer that she doesn't have an issue with drugs. She wants to go to Santa Maria for, I guess they've got a kind of like a cognitive track there also. But obviously, looking at the PSI report and everything that's in it, if they can give her help with drugs there, then that's certainly something that would be beneficial to her. She's ready, I think, to stop going to prison. She's realized that that's not something that she wants to continue to do. She's put herself in that position again today. But speaking with her, she's really ready to turn her life around. And regardless of what you do here today, Judge, she's asking for probation, but even if you send her to prison, I think she's made up her mind finally that this will be the last time that she comes into court for any kind of felony offenses. She's really hoping that you would give her the opportunity to go to Santa Maria and get that the tools that she needs to make the better decisions in her life.
When did you get off parole?
January.
January of this year?
Yes, ma'am.
So you committed these offenses. You got off parole and you thought, let's do it.
This is where the pattern becomes impossible to ignore. A long record, repeated chances, and now the court has to decide whether rehabilitation is still possible or if it's finally time for real consequences.
Bless you.
In addition to the state jail priors that are listed in the indictment, there's also a burglary conviction.
Yeah, she got 7 years. That's the one she was
That's
on
correct.
parole for. So you've been convicted of a burglary of a habitation, a theft of a firearm, previous theft, got probations on all of those, even at different times. It looks like you were on probation for the burglary and the theft of a firearm, and then someone, potentially me, I don't know whose court that was in, but here, left you on probation and gave you 2 probations on those new thefts, and then you violated all that after getting those, and now you're here. Okay. All right, Ms. Faye, okay, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of credit or debit card abuse, find those prior offenses, convictions true. Going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You're lucky that you got the cap. Mr. Rojas did a good job. It's rare that you're going to get rewarded for more bad behavior. You already got a 7-year sentence. You probably should be getting worse than that instead of going down. So you will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, ma'am. You can go back with the bailiff.
Thank you, Your Honor.
That last defendant was building up a rap sheet like it was a personal hobby. Burglary of a habitation, theft of a firearm, using someone else's debit card, and who knows what else that hasn't even hit her file yet. If she hasn't been convicted of something, it's probably just because no one caught her in time. And yet she still somehow believed she deserved probation, which is wild when your criminal history reads like a discount crime anthology. When you stack charges like that and keep violating while on parole, the idea of another chance stops existing. She's already done 7 years and somehow managed to walk away today with only 5. She got unbelievably lucky that the agreement capped it there because a judge absolutely could have gone higher. Watching all these cases today honestly makes you question whether the sentencing system needs tightening because the number of repeat offenders is getting out of hand. At some point, consequences have to mean more than just a mild inconvenience. Do you think the courts are being too lenient, or is this just how the system is meant to work? I want to hear your thoughts below. Thanks so much for watching. Don't forget to like and subscribe, and I'll catch you in the next one.